I'm Tom Schumacher. I'm the managing shareholder at Bakke Norman, and at least with our group, have been the person the longest involved in the municipal law practice. And so with that, that's kind of the introductions, the basics. And so the first item on the agenda is this, for the group and for everyone, is the recent cases and legislative update. And first thing, I just want to talk about a couple of cases in a couple different areas. First thing I should say is that these case summaries came out of the Wisconsin lawyer Wisbar site. They do an annual review of all various practice areas, and I just went in there and I pulled some of the recent cases that were in the public sector municipal law section to give a summary of some of the decisions that have made over probably the last, I think it's maybe been a little over a year since we've had our last seminar, so decisions that have been made within that time frame. First couple decisions deal with zoning, and you know, that's something that affects all municipalities. This first case deals with a deck on a lake property, which is something that inevitably somebody puts their deck up, they build it too close to the lake shore, and then they want to come in after the fact and say, well, you know, I didn't really mean to do that, and I've already got it built, of course, and don't make me take it down. And, you know, it's amazing the number of zoning cases that deal with decks on lake shores, but that's there's been a lot of zoning law made with respect to that particular topic. And as a result of that, there's been legislation that deals with that, and it deals with how much you can have an encroachment. So the idea was you're supposed to be back 75 feet from the lake, but all these people, everyone builds their decks and then asks the question about that. And so now you have permission to have 200 square feet of floor footage within the setback area, and the Board of Adjustment, who's typically the body that's hearing these, is required to allow you to leave that there. And so what happened in this particular case is the cabin sits there, the lake shore's out here, and once you get 5 feet away from the house, you're now within the encroachment area. And so the parties, they build their deck, they come into the Board of Adjustment, their zoning office comes, says you've got a problem, so then they want a special exception. And so they request the special exception, and then they see this rule where you can have 200 square feet. And so what they do is they've got the infrastructure for the deck. So they've got the supports, the legs for the deck, and they've got the joists that come out towards the lake. And what they did is they started taking off the floor pieces back enough to where they got to 200 feet. And so the Board of Adjustment said, you know what, you guys are just trying to skirt the law here. This isn't going to work. And so what the Board of Adjustment says, no, that's not a requirement. You've got the infrastructures all there, and when you look at all of that together, it's more than 200 feet and 200 square feet, and so we're not going to allow it. And the property owners appeal. They go to the Court of Appeals, and what the Court of Appeals said is that the statute talks about total floor area. Floor area means something that you can walk on. And so the end result is that they allowed the property owner to keep the deck for that 200 square feet that was in the encroachment area, and they didn't have to take it down. And they overturned the decision of the Board of Adjustment, Board of Appeals, that was requiring them to remove the deck. Now, having said all that, they got to keep their deck, but I can guarantee you the cost of them going through the process, going to the Court of Appeals, they probably could have paid for several decks. And whenever I've got clients who come to me with lakeshore property when they're buying it, the first thing I say to them, survey the property. The second thing I say is, if you're going to build a deck, go to the zoning office, find out what the rules are, and then build it. And that's really true for in a municipal context for you as a regulating body and for the property owners themselves. Most often, if you at least go in and you ask the questions, generally it's going to work best for the municipality, it's going to work best for your citizens and your property owners. So that's the first case. Next case has to do, again, with an appeal from a Board of Adjustment, And I'd never really saw this issue, but it came up here. And so you have the Board of Adjustment, right? That makes the decision. The Board of Adjustment is the North Hudson Board of Adjustment. It's the Village of Baldwin Board of Adjustment. It's the, whatever the municipality might happen to be. And so what happened in this particular case is the parties appealed not made an appeal not from the Board of Appeals or the Board of Adjustment, but from the actual municipality. And so in this case, it was the city of Kenosha. And so they were appealing this adverse decision that they've gotten at the Board of Adjustment, and they served the notice on the city of Kenosha. The problem was that the city of Kenosha did not make the decision. The Board of Adjustment of the city of Kenosha made the decision, and so that was what was critical, and the court said, the city's the wrong party, you're out, you had the wrong, and dismissed the matter. Next couple cases talk about condemnation. That's the process generally where either for roads or utilities or something like that, the municipal body is going to take somebody's private property, and the way that that works is that they generally make a offer. There's some appraisals exchanged. They make a jurisdictional offer based on those appraisals, and then the property owner may or may not accept that. They can go get their own appraisal and proceed along that course. And in these cases, there were a couple of unique issues. This first one, 260 North 12th Street, had to do with when you look at the fair value and you're appraising this property that you're condemning, do you have to consider environmental cleanup issues with respect to that? And the court said that yes, you do, because when you're looking at the fair value of a piece of property, it's important, all of the factors, and you're supposed to look at all those factors. And if you're going to buy a piece of property and you know that you have $15,000, $20,000, $75,000 of environmental cleanup costs, that's what's going to affect what you're going to pay for the property. So obviously that affects fair value. Down a couple cases, down at the bottom of the page, another condemnation case is Winterberry versus Lake Delton. And this was a condemnation matter in Lake Delton, down in the Dells. A lot of property down there that's very high, very expensive property. And the issue there was, what type of an approach can you look at to value the property? And generally, when you think of valuing property, you think of using a market approach, which is you look at comparable sales of other property. You look at an income approach and how much income it generates and compare that for what the reasonable rates of return are. Or you use a cost approach and figure out what the cost of the property is. And similar things that are looked at not only in the condemnation, but in the assessment process when you're looking at valuing property. And so in that particular case, the property owner wanted to use the income approach because this was a piece of property that was going to be developed for, I can't remember which chain of restaurants it was, but it was going to be developed for this chain of restaurants. And as a result of the taking by the Department of Transportation in that particular case, the size of the restaurant, and I guess what my analogy would be is, you see these full-size McDonald's, but now there's a lot of smaller McDonald's. They're in with the C-stores in various locations. And so the result of this taking meant that they weren't going to have enough parking area, so they had to construct a smaller facility. And the argument of the property owner was that, well, we should use an income approach, and I'm going to get less income off of this property. That creates a bigger loss on my part, and that's what the court should look at. And the court has said in several cases that the income approach is generally not going to be used in condemnation proceedings because from that perspective there are too many factors that can affect income, and so they generally don't want to use that unless there's no other way to value the property, and they upheld that rule in that particular case. Next page, on page 12, talks about income impact fees. And you know, if people can think back to the time when actually real estate was booming, and that certainly hasn't been the case for the past few years. Growth, especially in St. Croix County, for a number of years, St. Croix County has been the fastest growing county within the state of Wisconsin. And when you have that growth, you've got a lot of infrastructure that you have to take care of. You've got roads you have to take care of. You've got municipal buildings you have to take care of. You've got utilities that you have to take care of. And You also have the mandates from the state, which limit the amount of tax revenue you can generate. And so one of the things that has been in a part of the statutes that came into play were impact fees. And the St. Croix Valley Home Builders, which is headquartered here in this particular area, was contesting the impact fees in a particular municipality. And the issue in this particular case was whether or not they had taken and exhausted their administrative remedies. And in the impact fee ordinance, they had a procedure where if you didn't think the impact fees were appropriate, you had to go through this procedure and contest those and give the opportunity to the municipality to look at that and make some adjustment. And in this particular case, they bypassed that. They went to court. Figured they weren't going to get a good shake at the municipal level and just went that way. And the court held that before you can come to court, you ought to take care of this, instead of putting it in the court's lap, you ought to take care of this at the local municipal level so that those situations get remedied by the people who are closest at hand. If you go that route and then you don't get satisfaction, yes, then you can come to the courthouse, but you need to exhaust your administrative remedies first. Next item is this Wisconsin Rapids School District case. A lot of open meetings, open records law cases are affected by technology. And, 25 years ago, we weren't worried about emails and what were contained in emails because nobody had them. Now we have those. And in this particular case, there was a citizen who was looking for information that was contained in emails of these teachers, and it really related to a school issue. But they wanted all of the emails of the teachers, not just the ones that may have related to the particular issue that they were inquiring about. They wanted all of the emails. And the school district had a policy that said you can have incidental use of your email that we provide at the school district for personal purposes. And so the citizen making the open records request wanted all the emails. When that happens, the municipality goes into this balancing test to balance the rights of the individuals whose emails are being requested and the public right to openness and visibility in municipal matters. Once that balancing test is done, then so the municipality can decide to release or not release, or the school can decide, whatever public agency it is, to release or not release the emails. Then the party whose emails are being requested has an opportunity to object. And so they objected in this particular case, and the court came down and said that those personal emails, even though they were on the school computer system, were not public records, because public records have to relate to municipal business. So to the extent that they're, emailing their kids or emailing somebody else on a personal matter, since the material in that email did not relate to the school, did not relate, or it couldn't relate to municipality, some work in the particular municipality, those were personal and they weren't required to be released. So more recently, at least in this particular area, one of the big issues has been frac sand mining. And Adam's going to talk to us a little bit about that, but he talked to somebody, I think in Hudson, I don't know if it was today or yesterday, and the person said to him, what's this frac sand mining? What's that all about? And Adam was like, haven't you picked up a paper here recently? And so anyway, that has been a hot topic, and there was a recent decision that just came down. We kind of refer to it to the Cooks Valley decision that talks about that particular issue. And so I'm going to let Adam talk about that frac sand mining and that decision for a couple minutes.